Go
Yes,
ahead.
thank you so much. For some time now, we've been dealing basically with family law matters, and we've traveled from the conception of the marriage promise. We also looked at um, the promise to marry and the breach of it thereof. We had also looked at the customary law marriage, its characteristics, and all of the things that pan out there. And then we further moved or veered into ordinance marriage. We looked at the various means by which marriages could be contracted. We further looked at when the marriage is contracted by ordinance, um, the various matrimonial offenses under the Matrimonial Courses Act, and then we also looked at the divorce proceedings itself. Now, in the course of the divorce proceedings, we come to a certain point or stage of the whole process where we call the spousal property and the settlement stage. So in the release as sought by the parties, um, there are always certain number of reliefs which would speak to the settlement of properties. And unless, of course, there are no properties between the parties, then that particular relief will not be sought. But where there are no properties, they could go for other reliefs, including alimony or compensation for that process. But today, our concern is in respect of spousal property. So, spousal property basically, without any vivid definition, deals with the fact that, or it constitutes family property, it constitutes household goods, um, and properties acquired before or during the marriage. And basically, properties acquired before the marriage are not necessarily subject to the settlement during the divorce proceedings. I say that because either of the persons under the Constitution is vested with the right to acquire property. You have a right to acquire property. So if Mr. A acquired land at Akosombo before they married, upon dissolution of the marriage, that particular property acquired before the marriage cannot be subject to settlement between the two parties. But properties that were acquired during the marriage are the properties that will be of utmost interest to the court so that it be shared among the parties. Now, the word shared is the most important word in in the whole settlement of property during
Mm.
the divorce stage. Now, again, this term of act has evolved from 1958 in our family law jurisprudence up until now. Again, when back in the day, sometime in 1958, 58